was letting intermittent blacks sleep in the barn, but she drew the line at providing them with blankets. No, she explained to Henry when she went to fetch one, they don't feel the cold like we do. Lou and Henry might well have grown up with the same narrow outlook, but for a stint as young adults in Washington, D.C., where my great grandfather had gone to work for a new dealer on Capitol Hill. After World War II, the couple moved back to Mississippi to raise a family, but already they had become outsiders. When massive resistance to Brown versus Board of Education broke out, they took to arguing with friends. Henry went a step further, writing caustic letters to the editor in favor of integration. This provoked the Citizens Council to blackball his fledgling law firm, and when ostracism and death threats followed, Lou and Henry decided to sell their home in Jackson and relocated to the comparable Tolerance Coast. Modest protests cost my grandparents' friends and fortune, but they related those events without bitterness. Acts of conscience might be punished in the short term, they believe, but history and righteousness were on their side. Too often, their home state of Mississippi has surrendered to hate, but they had faith that in the end, reason would triumph over ignorance and tolerance over bigotry. I believe that too, but as a child of the conservative counter-revolution, I was born in 1969, 5 months after the inauguration of Richard Nixon. See, now that's a historian right there. That's a historian. Yeah, yeah. So pretty much Richard Nixon, the racist, Donald Trump's daddy, was campaigning around this time and he was getting ready to win the election in 68 and become president. Yeah. I had to grapple into my adulthood with the fact that reality veered from my grandparents' sanguine expectations. Jim Crow was laid to rest, to be sure, but racial inequality persisted. Billboard-style demagoguery no longer got candidates elected at office, but harangue against crime, welfare queens, and affirmative action did. Schools were no longer segregated by law, but they remained mostly separate and unequal. In Lou and Henry's primes, African Americans had brave bullets to march against fear. But by the 1980s, young African American men were more likely to be marched off to prison. Although my grandparents always believed the South would become more like the rest of America, in the welfare, tax, military, and especially criminal justice policy, America became more like the South because all them Southern rednecks moved all over America and became doctors, lawyers, superintendents, teachers, professors, molding the minds of generations to come in their racist Southern, you know. That's what happens. That's what happens over time. That's why things, it's a cycle. You know what I mean? That's what happens over time. This book grew out of my many conversations with Lou and Henry over the years and the disillusionment I felt as the country turned away from their ideals. In their long lifetimes, my grandparents have witnessed their world change shape around them. During the presidential primaries, Lou pushed her worker into Hancock County's Democratic Party headquarters to make phone calls for Barack Obama, a candidate whose trajectory until recently defied imagination. Yet, in so many ways, the South of my grandparents' generation lives on. Mississippi's electorate remains firmly polarized by race. Economic disparities have widened. In the aftermath of Hurricane Katrina, the world was reminded how much two Souths, one black, one white, still occupy common soil. My grandparents lost everything in the storm. The normally placid waters of the Gulf rose up with biblical fury and swept their home from the earth, leaving behind only a debris-strewn concrete slab and the bronze shoe of their firstborn. In a sense, this book is an elegy for the inundated dreams that Lou and Henry cultivated in their Mississippi homes, as well as an effort to reanimate them. By journeying deep into the past, the following pages chart how the United States has arrived at an astonishingly punitive juncture in its history, so that we might, in turn, depart from it. By examining Southern injustices that have persisted far beyond the demise of segregation, this book yearns for the alternate America my grandparents thought they were bringing into existence half a century ago. May they see it emerge now. 50 years ago, he's still talking about 50 years ago. Chapter 1 is titled Prison Heartland. It has a quote. It says, "There's tough and then there's Texas tough" by Lieutenant Governor David Dewhurst. But we're gonna get back to Texas stuff. We're gonna get back to Texas stuff in a little bit. I'm trying to tell y'all, man, I'm an avid reader. Quite an avid reader. I'm not expecting anyone to be as avid a reader as I am, but I'm just saying, man, give it a shot. It don't hurt. The Color of Law. A forgotten history. A forgotten history of how our government segregated America by Richard Rustin. Levi Publishing Corporation, a division of W. Norton and Company, independent publishers since 1923, New York, London. Copyright 2017 by Richard Rustin, all rights reserved, printed in the United States, first edition. Content, you got the preface, then chapter 1, if San Francisco then everywhere. Chapter 2, public housing, black ghettos. Chapter 3, racial zoning. Chapter 4, own your own home. Chapter 5, private agreement, government enforcement. Chapter 6, white flight. Chapter 7, IRS support and compliance regulators. Chapter 8, local tactics. Chapter 9, state sanctioned violence. Chapter 10, suppressed incomes. 11, looking forward, looking back. Chapter 12, considering fixes. Then the epilogue, appendices, author's note and acknowledgement, all that good stuff. Okay. Preface. When from 2014 to 2016, riots in places like Ferguson, Baltimore, Milwaukee, or Charlotte captured our attention, most of us thought we knew how these segregated neighborhoods with their crime, violence, anger, and poverty came to be. We said they are de facto segregated, that they result from private practice, not from law or government policy. De facto segregation, we tell ourselves, has various causes. When African Americans moved into a neighborhood like Ferguson, a few racially prejudiced white families decided to leave, and then as the number of black families grew, the neighborhood deteriorated, and white flight followed. Real estate agents steered whites away from black neighborhoods and blacks away from white ones. Banks discriminated with redlining, refusing to give mortgages to African Americans or extracting unusually severe terms from them with subprime loans. African Americans haven't generally gotten the education that will enable them to earn sufficient incomes to live in white suburbs, and as a result, many remain concentrated in urban neighborhoods. Besides, black families prefer to live with one another. All this has some truth, but it remains a small part of the truth, submerged by a far more important one. Until the last quarter of the 20th century, racially explicit policies of federal, state, and local governments defined where whites and African Americans should live. Today's residential segregation in the North, South, Midwest, and West is not the unintended consequence of individual choices or otherwise well-meaning law or regulation, but of uneven public policy that explicitly segregated every metropolitan area in the United States. The policy was so systematic and forceful that its efforts endure to the present time. Without our government's purposeful imposition of racial segregation, the other causes, private prejudice, white flight, real estate steering, bank redlining, income differences, and self-segregation, still would have existed, but with far less opportunity for expression. Segregation by intentional government action is not de facto. Rather, it is what courts call de jure. De jure, segregation by law and public policy. Residential racial segregation by state action is a violation of our Constitution and its Bill of Rights. The Fifth Amendment, written by our Founding Fathers, prohibits the federal government from treating citizens unfairly. The 13th Amendment, adopted immediately after the Civil War, prohibits slavery or, in general, treating African Americans as second-class citizens, while the 14th Amendment, also adopted after the Civil War, prohibits states or their local governments from treating people either unfairly or unequally. The applicability of the 5th and 14th Amendments to government sponsorship of residential segregation will make sense to most readers. Clearly, denying African Americans access to housing subsidies that were extended to whites constitutes unfair treatment, and if consistent, rises to the level of a serious constitutional violation. But it may be surprising that residential segregation also violates the 13th Amendment. We typically think of the 13th as only abolishing slavery. Section 1 of the 13th Amendment does so, and Section 2 empowers Congress to enforce Section 1. In 1866, Congress enforced the abolition of slavery by passing the Civil Rights Act, prohibiting actions that it deemed perpetuated the characteristics of slavery. Actions that made African Americans second-class citizens, such as racial discrimination in housing, were included in the ban. In 1883, though, the Supreme Court rejected this congressional interpretation of its power to enforce the 13th Amendment. The court agreed that Section 2 authorized Congress to pass all laws necessary and proper for abolishing all badges and incidents of slavery in the United States, but it did not agree that exclusions from housing markets could be a badge or incident of slavery. In consequence, these Civil Rights Act protections were ignored for the next century. Today, most Americans understand that prejudice towards and mistreatment of African Americans did not develop out of thin air. The stereotypes and attitudes that support racial discrimination have their roots in the system of slavery upon which the nation was founded. So to most of us, it should now seem reasonable to agree that Congress was correct when it determined that prohibiting African Americans from buying or renting decent housing perpetuated second-class citizenship that was a relic of slavery. It also now seems reasonable to understand that if governments actively promoted housing segregation, it failed to abide by the 13th Amendment's prohibition of slavery and its relics. This interpretation is not far-fetched. Indeed, it is similar to one that was eventually adopted by the Supreme Court in 1968, when it effectively rejected its 1883 decision. In 1965, Joseph Lee Jones and his wife, Barbara Jo Jones, sued the Alfred H. Meyer Company, a St. Louis developer who refused to sell them a home solely because Mr. Jones was black. 3 years later, the Supreme Court upheld the Joneses' claim and recognized the validity of the 1866 Civil Rights Act declaration that housing discrimination was a residue of slave status that the 13th Amendment empowered Congress to eliminate. Yet, because of an historical accident, policymakers, the public, and even civil rights advocates have failed to pay much attention to the implications of the Jones versus Meyer decisions. 2 months before the Supreme Court announced its ruling, Congress adopted the Fair Housing Act, which was then signed into law by President Lyndon Baines Johnson. Although the 1866 law had already determined that housing discrimination was unconstitutional, it gave the government no powers of enforcement. The Fair Housing Act provided for modest enforcement, and civil rights groups have used this law rather than the earlier statute to challenge housing discrimination. But when they did so, we lost sight of the fact that housing discrimination did not become unlawful in 1968. It had been so since 1866. Indeed, throughout those 102 years, housing discrimination was not only unlawful but was the imposition of a badge of slavery that the Constitution mandates us to remove. The Color of Law, this book, is concerned with consistent government policy that was employed in the mid-20th century to enforce residential racial segregation. There were many specific government actions that prevented African Americans and whites from living among one another, and I categorize them as unconstitutional. In doing so, I reject the widespread view that any action is not unconstitutional unless the Supreme Court says so. Few Americans think that racial segregation in school was constitutional before 1954, when the Supreme Court prohibited it. Rather, segregation was always unconstitutional, although a misguided Supreme Court majority mistakenly failed to recognize this. Yet, even if we come to a nationally shared recognition that government policy has created an unconstitutional de jure system of residential segregation, it does not follow that litigation can remedy this situation. Although most African Americans have suffered under this de jure system, they cannot identify with the specificity a court case requires, the particular point at which they were victimized. For example, many African American World War II veterans did not apply for government guaranteed mortgages for suburban purchases because they knew that the Veterans Administration would reject them on account of their race, so applications were pointless. Those veterans then did not gain wealth from home equity appreciation as did white veterans, and their descendants could then not inherit their wealth as did white veterans as descendants. With less inherited wealth, African Americans today are generally less able than their white peers to afford to attend good colleges. If one of those African American descendants now learned that the reason his or her grandparents were forced to rent apartments in overcrowded urban areas was that the federal government unconstitutionally and unlawfully prohibited banks from lending to the African Americans, the grandchild would not have the standing to file a lawsuit, nor would he or she be able to name a particular party from which damages could be recovered. There is generally no judicial remedy for policy that the Supreme Court wrongheadedly approved. That's why the family of Henrietta Lacks could never get justice. There is generally no judicial remedy for policy that the Supreme Court wrongheadedly approves. There's not. There's not. Like, I, I hope this gets out in time, and thanks to Jeff Flake, I hope you don't retire, brother. I hope you don't retire, man. Come to the good side, man. Come to the good side, man. Let the Republicans alone. You finally tapping into your Americanness. You don't want to be part of anything that's undercover whiteness, undercover racism. You know what I mean? Come to the Democratic Party, man. Come join the blue wave. I guarantee you, if you join the Democratic Party, you'll wake up that next morning, man, feeling so good, boy. You gonna feel so good, man. You gonna feel so good, man. But yeah. What I was about to say though, I hope Brett Kavanaugh doesn't end up as Supreme Court justice, y'all. I hope it doesn't. I really hope it doesn't. Like, decisions made by that court cannot be. But this does not mean that there is no constitutionally required remedy for such violations. It is up to the people, to our elected representatives, to enforce our constitution by implementing the remedy. See, I have written, and I had gotten to this part right here. See, I have written, I say read and vote, like you can barely see it. Like that's what I'm asking, man. Pick up a book and read. And I'm not talking about reading on your tablets or nah. Those are like the worst distractions ever when you're trying to read something. But yeah. But this does not mean that there is no constitutionally required remedy for such violations. It is up to the people, to our elected representatives, to enforce our constitution by implementing the remedy. By failing to recognize that we now live with the severe enduring effects of de jure segregation, we avoid confronting our constitutional obligation to reserve it. If I am right that we continue to have de jure segregation, then desegregation is not just a desirable policy, it is a constitutional as well as a moral obligation that we are required to fulfill. Let bygones be bygones is not a legitimate approach if we wish to call ourselves a constitutional democracy. Racial segregation in housing was not merely a project of Southerners in the former slaveholding Confederacy. It was a nationwide project of the federal government in the 20th century, designed and implemented by its most liberal leaders. Our system of official segregation was not the result of a single law that consigned African Americans to designated neighborhoods. Rather, scores of racially explicit laws, regulations, and government practices combined to create a nationwide system of urban ghettos surrounded by white suburbs. Private discrimination also played a role, but it would have been considerably less effective had it not been embraced and reinforced by government. Half a century ago, 50 years ago, the truth of de jure segregation was well known, but since then we have suppressed our historical memory and soothed ourselves into believing that it all happened by accident or by misguided private prejudice. Polarized by Supreme Court majorities from the 1970s to the present, the de facto segregation myth has now been adopted by conventional opinion, liberal and conservative alike. A turning point came when civil rights groups sued to desegregate Detroit public schools. Recognizing that you couldn't desegregate schools if there were few white children in Detroit, the plaintiffs argued that the remedy had to include the white suburbs as well as the heavily African American city. In 1974, by a 5-4 vote, the Supreme Court disagreed. The majority reasoned that because government policy in the suburbs had not desegregated Detroit school, the majority reasoned that because government policy in the suburbs had not segregated Detroit schools, the suburbs couldn't be included in a remedy. Justice Potter Stewart explained that black students were concentrated in the city, not spread throughout Detroit suburbs, because of unknown and perhaps unknowable factors such as in-migration, birth rates, economic changes, or cumulative acts of private racial fears. He concluded, the Constitution simply does not allow federal courts to attempt to change their situation unless and until it is shown that the state or its political subdivisions have contributed to cause the situation to exist. No record has been made in this case showing that the racial composition of the Detroit school population or their residential patterns within Detroit and in the surrounding areas were in any significant measure caused by governmental activity. Most disturbing about Justice Stewart's observation was that the civil rights plaintiffs did offer evidence to prove that residential patterns within Detroit and in the surrounding areas were in significant measure caused by governmental activity. Although the trial judge agreed with this argument, Justice Stewart and his colleagues chose to ignore it, denying that such evidence ever existed. Alright, there's this asterisk next to the end of that paragraph. From this evidence, Federal District Court Judge Stephen J. Roth, in his opinion that was overruled by the Supreme Court, concluded the policies pursued by both government and private persons and agencies have a continuing and present effect upon the complexity of the community. As we know, the choice of a residence is a relatively infrequent affair. For many years, FHA and VA openly advised and advocated the maintenance of harmonious neighborhoods, i.e., racially and economically harmonious. The conditions created continue. Judge Roth urged that to acknowledge that other factors were also involved, we need to minimize the effect of the actions of federal, state, and local governmental offices and agencies, and the actions of loaning institutions and real estate firms in the establishment and maintenance of segregated residential patterns which lead to school segregation. This misrepresentation of our racial history, indeed, this willful blindness, became the consensus view of American jurisprudence, expressed again in a decision written by Chief Justice John Roberts in 2007. His opinion prohibits a school district in Louisville and Seattle for accounting for students' race as part of modern school integration plans. Each district permitted students to choose which school they would attend, but if remaining seats in the school were limited, the district admitted students who would contribute to the school's racial balance. In other words, black students would get preference for admission to mostly white schools, and white students would get preference for mostly black ones. The Chief Justice noted that racially homogeneous housing arrangements in these cities had led to racially homogeneous student bodies in neighborhood schools. He observed that racially separate neighborhoods might result from societal discrimination, but said that remedying discrimination not traceable to government-owned action can never justify a constitutionally acceptable racially conscious remedy. The distinction between segregation by state action and racial imbalance caused by other factors has been central to our jurisprudence. Where racial imbalance is a product not of state action but of private choice, it does not have constitutional implications. Because neighborhoods in Louisville and Seattle has been segregated by private choices, he concluded, school districts should be prohibited from taking purposeful action to reverse their own resulting segregation. Chief Justice Roberts himself was quoting from a 1992 decision by Justice Anthony Kennedy in a case involving school segregation in Georgia. In that opinion, Justice Kennedy wrote, he's the one that's retiring, right? Justice Kennedy, Kavanaugh, it's your fault. You should have stayed. I know. I know. Father time is calling out, man. You know what I mean? So, I know. Man, if it wasn't for you, John. Alright, yeah. I gotta get some coffee.